All right, so let's talk about the pretrial conference. First off, pretrial conference by any other name, still a pretrial conference. Different counties may refer to it as a case management conference or a status hearing or something along those lines. In essence, what the pretrial conference is, it's just a fork in the road. What the judge wants to know at the pretrial conference is, are you going to trial or are you going to resolve the case without a trial? It could either be a plea, it could be a dismissal, it could be a diversion agreement, something else like that. So that's what's going on. Normally at the first pretrial conference, you haven't figured that out yet. Normally that's because you haven't done interviews, there's motions that need to be filed. So it's very, very common at the first pretrial conference to walk in and say, Judge, we're not ready to make that decision. The judge won't give you any grief at that time and they'll set it to another pretrial conference, usually 30 days down the road. At some point, if you've got too many pretrial conferences reset, the judge may say, hey, this case needs to get to trial, it's taking too long. The judge could just set it to a trial. But normally what happens is there's at least one or two or maybe even three continuances of that pretrial conference. If your attorney is working on the case and things are getting done and interviews are occurring, motions are getting filed, the judge will generally give you a continuance of the pretrial conference. So again, pretty low stress hearing. You ought to know in advance from your lawyer exactly what the plan is at the pretrial conference. But if you're not in and out of there in a couple of minutes in terms of that hearing, probably there's something else going on you should know about. Very low stress hearing. That's what the pretrial conference is about.